Honorable members, we will now turn to the Real Estate Agents and Brokers Bill 2023, Bill number 11 of 2023, published on the 19th of July, 2023. Honorable Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlall.
Thank you very much, Mr. Speaker. I rise to move that the Real Estate Agents and Brokers Bill 2023, Bill number 11 of 2023, published on the 19th of July 2023, be now read a second time. Mr. Speaker, the real estate business has been part of our commercial sector from time immemorial. Currently, the real estate sector in Guyana is without any regulation whatsoever. It is a sector which generates perhaps over billions of dollars annually in the sale and leasing of real property. It employs dozens of persons. With the exponential growth in the Guyanese economy and the increase in foreign and local investments, in particular in the oil and gas sector and in the hospitality and accommodation industry, the sale and rental of properties increase significantly, enlarging the industry even further. International real estate operators such as Century 21 of the United States and RE/MAX from Canada have established offices in Guyana. Over the years, citizens across this land can relate to unfortunate experiences and fraud to which they have been subject at the hands of persons holding themselves out as real estate agents. These persons have no prescribed qualifications, are not supervised by any authority, neither are there any regulatory framework within which they are to operate. There is no fixed rate anywhere which dictate how they are to be remunerated. Significantly, no clear rules exist which stipulate how they are to be retained, nor a code of conduct to which they are bound. It is simply a free for all. This has led to arbitrary and capricious conduct, exploitative practices, unfair and irregular dealings, fraud, and illegalities. From a financial and accounting perspective, there is no regulatory framework as indicated above, and therefore no effective supervision, monitoring, or accountable regime for the type of transaction conducted and the revenues generated therefrom. State agencies such as the Guyana Revenue Authority and the Financial Intelligence Unit have no institutional mechanism in place to audit, monitor, supervise, or verify the affairs of this multi-billion-dollar sector. In this modern age, this state of affairs is completely unacceptable. Expectedly, this sector has been flagged as a weak link in Guyana's anti-money laundering and countering the financing of terrorism framework. Guyana has been directed to rectify this gaping deficiency. All the aforesaid factors concatenate to the drafting and promulgation of this important piece of legislation. It constitutes yet another step in the journey of modernizing our legislative and commercial landscape. This bill sets out a comprehensive regulatory framework that will govern the real estate industry in Guyana. Importantly, it is expected to correct the identified weaknesses in our AML-CFT architecture in time for an impending assessment to which our financial system will be subject in September 2023, by assessors from the Caribbean Financial Action Task Force in a mutual evaluation exercise. This bill has been in the pipeline for more than a decade. However, work began earnestly last year and concluded this year. The drafting of this bill constituted a collaborative effort between the Government of Guyana, through the Attorney General Chamber's AML-CFT unit, and the operators in the real estate sector in Guyana. There are two main real estate associations in Guyana, namely the Realtor Association of Guyana and the Guyana Association of Real Estate Agents. I chaired several engagements with representatives of both of these organizations. Both organizations produced draft bills, and one was generated from the AML-CFT unit of the AG Chambers. The bill that is before us is the end product of a consensual merger of these three draft bills. The draft produced by the two associations contain provisions extracted from real estate legislation from both the US and Canada. The draft which the AG Chambers generated was crafted after consulting similar legislation in the Caribbean, in particular Trinidad and Tobago. Needless to say, the provisions were appropriately adjusted to meet the exigencies of the Guyanese reality. And Mr. Speaker, I will go briefly into the bill, the important clauses. Clause 6 outlines, clause 5 begins with a definition of what is a real estate activity. And as expected, it is a detailed definition spanning some 2 pages. So the bill governs real estate dealings, and one of the first things that the bill does is to comprehensively define what is a real estate dealing. Clause 6 outlines the instances where persons are not involved in real estate business, such as attorneys at law facilitating a conveyance, persons operating under a power of attorney, an administrator, executor, or trustee, or a person involved in selling or leasing their own private property. So after the bill describes what a real estate activity is, the bill then goes on to say that there are categories of persons who may be engaged in this activity, but they will not be considered real estate activities for the purpose of the bill. So if you are selling your own property, if an attorney at law is selling a property on your behalf, or if you are administrator of an estate or executor of a will, and you have as part of your responsibility to sell properties of the estate, and you actively go out there and seek buyers or seek purchasers, or you have to rent properties as part of your fiduciary duties as an administrator or executor, and you have to go out there and seek tenants, you will be performing an activity that is captured in the definition. And the bill ought to apply to you, because the bill requires that if you're going to conduct these activities, you have to be registered, etc., under the bill. But the bill accepts the category of persons to whom I'm making reference, because the bill allows that narrow category of persons to conduct real estate transactions unaffected, and are going to be unaffected by the bill. So any person outside of this exempted or accepted category who conducts a real estate transaction, unless authorized by the Act, will will be committing an unlawful act. And that is what Clause 6 does. So all persons who are now going to operate as real estate agents conducting real estate activities must now come under the supervisory authority of the framework that this bill will establish when it comes into law. And only those persons who are accepted will not have to come under the administration of the Act. And the bill goes straight into registration. A person who wishes to engage in real estate business shall apply to be registered with the Guyana Real Estate Authority under Clause 26. The bill makes it unlawful for anyone to act as a real estate agent or broker unless that person is registered. As a reporting entity under this AML-CFT regime, it is of critical importance that provisions enable real estate agency to carry out their AML-CFT reporting obligations effectively and efficiently. Let me pause here to explain that, and I did it en passant in my introductory remarks, one of the reasons why this bill is here is to answer a query raised by the Caribbean Financial Action Task Force. They have already identified real estate activities in Guyana as an area for potential concern for AML-CFT purposes, and they have directed a regulatory framework, and that regulatory framework must adequately cater for proper record keeping, proper documentation, proper licensing, proper supervision, proper monitoring, not only to keep the industry intact, but also because of the potential that this industry has in terms of AML-CFT. As I said, billions of dollars pass through this industry. And one of the fastest way of laundering money, one of the most effective and popular way of laundering money is through real estate. Is to create a front, create a property, create companies, and through these companies, wash dirty money, wash tainted proceeds. So that is a universally recognized phenomenon. So our bill confronts that reality expressly and in a most elaborate way. We don't do it in any disguised way. We say frontally in the bill that this is one of the functions, duties, obligations, and responsibilities of those who are going to operate in this sector. In order to be registered under this bill, this applicant must fill out an AML-CFT questionnaire. They must also be 18 years of age and hold the prescribed qualifications to be determined by the authority. Real estate agents and brokers will also be required to keep clients' account, that is, accounts that are separate from their personal account with regard to management of funds of clients. Here again, you see the hand of accountability and transparency. In any event, anytime you're dealing with funds that are not yours in the conduct of your business, whatever the endeavor is, you are to treat that separately from funds of your own. They must not be intermingling and commingling unless the law permits it, or there is some ethical acceptance of a guideline that will allow for the intermixture and admixture of funds. This bill speaks to that in an express way. They must keep proper records of transaction in keeping with the statutory requirement of 7 years under the AML-CFT in a manner that the authority can retrieve such transactions where necessary. All transactions, like commercial banks are required to do, must be saved, must be stored, must be kept for a statutory period of 7 years. That is the international requirement across the sectors. The real estate operators are now brought into fold to comply with that requirement. Clause 21 established an authority to be known as the Guyana Real Estate Authority and provides that the authority shall be a statutory body corporate. The authority will provide a licensing and registration regime for real estate agents and brokers. I want to pause here to ask you to observe that this is a sector-driven bill. It's a commercial sector-driven bill. And if you listen or if you read the bill itself, you will see that there is hardly a hand of government anywhere. It's a sector that is established to run and manage itself, and that is why the authority is a statutory body corporate, but somebody must appoint the authority, and that's where a minister comes in. The authority can be appointed by itself. So when you see a minister, you must not get on you. I noticed this tendency in this house. Whenever the word minister appears, it's clouded, suspicion, baseless suspicion arises. Baseless suspicion arises. Listen, laws are going to be administered by the executive. They are going to be enforced by the enforcement agencies. They have to be administered by ministers who are answerable to the people through this parliament. And there is nothing wrong. This government is not going to cede power that it was elected to exercise. So I want you to disabuse your mind about that. It will comprise of representatives from the Real Estate Association, a nominee by the Attorney General, as well as a nominee from the Ministry of Commerce, the Consumer Affairs Commission, and the Private Sector Commission. These members shall hold office for a term not exceeding 3 years and are eligible for reappointment. By clause 32 of the bill, the authority shall submit to the minister a report on the performance of its functions annually, and the minister shall, within 3 months of receiving that report, cause the report to be laid in the National Assembly. That is the point that I am making. To bring you involved, bring the people involved. Never mind, it's a commercial entity operating in the private sector. But whether you see minister, suddenly you see Jambi. You look like that. Clause 23 of the bill lists the grounds upon which members would be disqualified. Members of the authority. So it has qualifications for members of the authority, and it has disqualifications. Importantly, notices of applications for license under the Act are required by the authority to be published in the official gazette and in 2 daily newspapers circulating in Guyana for the purpose of inviting objections to the grant of license. So here you have it, where persons are interested and wish to apply to be granted a license, the authority is obliged to put that application, a notification of that application, in the official gazette and in newspapers enjoying daily circulation, so that members of the public can, if they wish, object to that appointment, object to the grant of that license, if you believe that this person does not possess the moral rectitude to perform the functions, or whatever reason you may have to disqualify him. Of course, a mechanism is established in the bill that allows fairness and due process. Not because Honorable Member Mrs. Chandan doesn't like a particular person, she can object, and that's the end of the matter. The objection has to be processed, and there will be a hearing, and a determination will be made after hearing both sides. And if anyone is aggrieved by a decision of this authority, be it Ms. Chandan as the objector, the potential applicant, or anyone else, they are free to approach the High Court to seek judicial review of that decision that they feel should be impugned. A license issued under the Act shall be valid for 3 years from the date of its issue unless it is cancelled, suspended, or revoked. And there is an allowance also for the renewal of these licenses. The authority has some general functions. They include, quickly, the determination of qualifications for real estate agents and brokers. So for the first time, we will have qualifications that will be prescribed by regulations, not by the minister, but by the authority. Maintaining and updating the register of real estate agents, maintaining and updating maintaining and updating the register of real estate agents, the issue, renewal, revocation, or cancellation of licenses, informing the supervisory authority of the issue, renewal, revocation, or cancellation of a license, issuing guidelines and codes of practice for real estate agents and brokers from time to time, and any other function as may be determined by the authority to be necessary for the real estate sector. So you have qualifications which are going to be prescribed, disqualifications are going to be prescribed. You will have a register of the operators in the sector. You will have details of their license renewals, etc. And most importantly, you will have guidelines and codes of conduct that will govern their behavior and the conduct of their affairs in the sector. So you're going to have now a framework of regularity that will exact from operators of in the sector professionalism, efficiency, and honesty. The bill sets out a variety of conduct which, if committed by a real estate agent or broker or sales associate, would be guilty of professional misconduct. It is quite an exhaustive list spanning over 3 pages in the bill at clause 40. And I'm not going to exhaust you with it. Look at it, there's a whole long line of wrongdoings or conduct that are classified as wrongdoings, and they form part of the rubric of professional misconduct if they are committed and the perpetrator is found guilty. Clause 40 also provides that where an act of unprofessional conduct is established by a broker, the directors, partners, or management of that broker is deemed to have committed the offense, provided that they consented, connived, or acquiesced to the said misconduct. So when a body corporate goes out and commits a misconduct, the principals, the human beings behind that body corporate, the director, the CEO, or the officers of the company, once it can be established that they connived, they authorized, they consented, or they acquiesced to that misconduct, then they are as guilty as if they had performed it personally. Part 6 deals with duties and obligations of persons involved in the real estate business. So in addition to a code of conduct that will come, in addition to all the other obligations in the bill, qualifications, etc., there is also a provision that lists the important duties and obligations that devolve upon operators in the industry. These include the maintenance of proper record of all transactions conducted, maintenance of clients' accounts, where clients' monies are to be deposited separately and distinct from their accounts. Significantly, the bill makes it clear that clients' monies are held in trust, and if misused, a criminal offense is committed, which upon summary conviction attracts a fine of $5 million and imprisonment for 5 years. The agents and the brokers are also required to file on an annual basis accounting records of their business with the authority. In this regard, if false information is submitted, another criminal offense is committed. So here again you have monies. We have had or every lawyer in this room can relate to a client walking into their office, or many of you in your daily lives can relate to persons who would have complained to you of fraud perpetrated against them in some property transactions. Invariably, and I say so with the greatest of respect to the honest operators in the real estate industry, the main architects or intellectual authors of these property frauds have been persons holding themselves out as or trading as real estate agents. They do it with the use of power of attorneys, they get false transport, all sorts of manifestations of it. Here, they now are bound. First of all, we will have qualifications. Then you have, before license are granted, you have an opportunity to object. Then you have code of conduct to which they will have to be compliant. And now you have duties and obligations of a more penetrative nature in terms of how they conduct their actual affairs within the four corners of their office. The bill establishes a disciplinary committee which will hear and determine complaints made against a real estate agent or broker and any other matters related to professional misconduct by a real estate agent or broker. The committee will not be under the control or direction of any person and is therefore completely independent. This panel will consist of an experienced attorney at law as its chairperson, as well as two other experienced persons in the real estate arena. If the committee has been satisfied that an act of professional misconduct has occurred, it has the power to reprimand or censure the real estate agent or broker, recommends the authority that the certificate of registration of the real estate agent or broker be suspended for a period not exceeding 2 years. C, recommend to the authority that the license of the real estate broker be revoked or agent be revoked. The disciplinary committee may also recommend cancellation of a certificate of registration or revocation of a license on the ground that the broker was convicted of an offense under this act or an offense of the laws listed in the first schedule. And the first schedule has some offenses that are very serious, which relate to money laundering, terrorism, financing, or proliferation financing. The formidable regime established by this bill, which addresses conduct and discipline and sanctions in this sector, will no doubt exact professionalism and rectitude from operators in the sector. There is a penalty section, and the bill creates a heavy regime of penalties, and various offenses are created throughout the bill. But there is a residuary penalty section, if you wish, at the end of the bill, and it says, wherever an offense is created and there is no penalty, this penalty listed here shall apply throughout. It states that on summary conviction, in the case of a body corporate, to a fine of 10 million, a body corporate to a fine of 10 million, a director or other officer of a body corporate to a fine of 10 million or imprisonment for 1 year or both. Any other individual to a fine of 5 million or imprisonment for 1 year or both. And on conviction and indictment in the case of a body corporate to a fine of 20 million, a director or other officer of a body corporate to a fine of 20 million or imprisonment for 2 years or both. Any other individual to a fine of 10 million or imprisonment for 2 years or both. So it's quite a heavy penal regime for offenses committed. And these, as I said, are the generic offenses. Almost every other section in the bill or every other part of the bill, when it legislates a particular conduct, and if it provides for an offense to be committed if there is a breach of that particular conduct that is mandated. Based on the concerns of real estate groups, we have included in this legislation that all agreements are to be in writing. This will ensure that there is a clear understanding of the relevant terms and conditions between the real estate broker and the client. One of the big disputes, one of the issues of controversies in the real estate sector is the rate of remuneration. As it exists now, there is none. There is no standard rate. So invariably, there is a fight that arises when the payment is to be made. The real estate agent will tell you that their understanding is X% of the sales price as commission, and the person who is to pay will tell you, no, that's not my understanding. And that is right there is a dispute. We believe that if that transaction is recorded in writing by law, then all those vagaries, all those ambiguities will disappear. They will be bound by the written contract. To ensure that the Act operates on a level playing field, all applicants who qualify as real estate agents or brokers shall be registered as real estate agents only from January 1st, 20. So let me pause here. So the Act will come into operation soon. You have a whole set of persons in Guyana already operating as real estate agents. You can't pass a law to outlaw them instantaneously. Rather, you have to pass a law to accommodate them. Right now, there are no qualifications. So what we decided, when this law comes into force, they will all be accepted and licensed at one level as real estate agents. Later on, brokerage, or to be a broker, is apparently a higher stage in the industry. It requires higher qualifications. Now, as I said, we have Remax agents here and we have Century 21 agents here. So they are already brokers. If we are to license them tomorrow, we will cause serious problems within our own local sector, because you have real estate operators here who have been in the industry before I was born, and they are still operating. And you know them, their names, some of them are household names in the country. I hate to believe that a young man, because he has a piece of paper somewhere that qualifies him as a broker, should come and enjoy a superior status to a real estate agent who has been operating in Guyana for the past 50 years. I don't believe that unequalness should be tolerated or should be encouraged at all. So what we did, the slate is clean, and all the operators in the sector are going to be accepted, registered, and licensed as the one-off. And then the industry kicks off. Brokers will come in 2026, and that was what I was going to read. From January the 1st, 2026, the authority will then begin to register such qualified persons as brokers. From now to 2026, requirements are going to be put in place now. Qualifications are going to be put in place by regulations. And real estate agents that will now enter the industry after the Act comes into force, after these qualifications are prescribed, will now have to meet those qualifications. And those who wish to be elevated in the status of brokers will now have to meet those qualifications. But that regime will come into force in January 2026. This enables a fair playing field from the commencement of the bill. The bill well, like I explained, the transitionary, those who are here already and are performing the functions, they will simply continue to perform, but they will now have to get their license and be registered, etc., under the bill. Now, I have received from a member from the other side, a list of proposed amendments, and I am aware of a request to send this matter to a select committee. Now, first of all, as I said earlier, this bill has to be passed in time for our on-site mutual evaluation assessment exercise slated to begin on the 6th of September 2023. It will go until the 16th of September. So this bill has to be in place for that. Secondly, this bill has been This bill has been in the public domain, as I said, for quite a while. The bill has received the input from the sector. And as I said, it's a consensual product of the two agencies or the two groupings operating as real estate agents in Guyana. Thirdly, I have looked at the list of amendments and I am unmoved. I am unmoved by them. They don't change anything in the bill. They're just amendments because someone wants to propose amendments. They don't add to the quality of the bill. They don't add anything of substance. As I said, this bill has received the inputs from the United States, from Canada, and I have the raw data with me. I have the bill, the various emails and various clauses of bills that I received from the various players in the industry, all of this. Excerpts of the Toronto real estate law, New York real estate law, and so on. So, unfortunately, we will not be able to accede to either requests, which one is to support the amendments that are to be proposed. Neither will we be